This is Erica Maryland. I'm the founder of Perfect Legal Video, and I am very excited to have with me today Attorney Jim Sorenson of the Sorenson Van Leuven law firm down in Tallahassee, Florida. And he has a law firm that handles all kinds of cases for credit unions in both Georgia and Florida. And I just want to welcome you today, Jim. Thank you so much for joining us this afternoon.
Erica, thank you for having me. It's good to see you today.
Great to see you. Now, today we are going to be starting a mini series, let's call it, of information on common myths that you hear in this industry. And I love busting myths in the law because there are just so many. And I think part of the reason is because there's TV and what you hear from your neighbor, and it's a lot of it's like a game of telephone. You hear it from 10 people. By the time you get the message, it's completely different than what the truth is. I don't know if you would agree with that analogy.
I would. I do think that a lot of these myths come from, well, I talked to our lawyer and our lawyer said this, but that's been translated now 5, 6, maybe 10 times, like you say. And so by the 10th person downstream, the actual advice of the lawyer has morphed into something that isn't recognizable. And so I do think that's where some of this comes from, this misinformation, and it just keeps getting repeated. And so those are some of the things we're going to be discussing in the mini series.
I'm so excited to hear all these. Now, today's is one that I hadn't heard of before, and we're going to be talking about paper repossessions. And I don't know what this is. So can you give us a definition of what the paper repossession is?
Yes, a paper repossession, and this is something that, unless you're in the industry, in the collections field of credit unions, you probably would not have heard this before. But it's often used to describe a situation where the lender does not actually repossess the collateral. They're just processing paperwork like a repossession, hence the term paper repossession. And they're trying to do that so they can get title to the collateral in their name, so they then can pass title or give title to another person, to a third party. Most of the time this happens, it involves things like motor vehicles, boats, RVs, those types of things is where we typically see it.
In this myth, where do you typically see this happening? What is the situation in which a credit union might be doing a paper repossession?
Yeah, so I think it comes up mainly in 3 scenarios. There's certainly probably some other scenarios where it comes up, but the ones that I typically see or I'm typically contacted about usually are one of 3. And it's, let's say we have a vehicle, if it's an auto loan, a motor vehicle, it could be a boat, an RV, but I'm going to use vehicle as our example as we talk. So let's say we have a vehicle that gets totaled, it's involved in an accident, it's destroyed, it's not repairable. And the borrower, owner of the collateral, is not cooperating with the insurance company. And the credit union or the lender wants to settle the claim with the insurance company, but the borrower has gone dark, has gone silent, is not cooperating. And so, they want to get title into their name, settle the claim. And so we see it there. We see it where the borrower or collateral owner is dead, and the lender wants to transfer title to a third party who is paying the loan, say a child or a brother or sister, maybe parents, that type of thing. And then we see it in the third scenario, which often is the most messy, is a divorce or something like a divorce. They may not be legally married, but they were living together, romantically involved typically, and one person is on the title to the vehicle, but they're both on the loan. And now they're separated, they're not getting along anymore. One of them's paying the loan, wants to protect their credit, the other one doesn't care. They're usually using the car as leverage against each other, and the credit union's kind of stuck in the middle of that dispute. And so a lot of times they want to get the car title into the name of the person who's paying, and enter that dispute. And so, in each of these scenarios, the credit union is transferring title, but they're not actually repossessing the car. And so these become known as paper repossessions.
Oh my gosh, it sounds like you should really consider writing a soap opera about what happens with some of these situations. Because it just sounds so exciting.
There are stories, and I could tell stories, but yes, sometimes they get real messy.
Yeah, you got to take out the names to protect the not so innocent.
Yeah, it's not so innocent, or maybe not so wise with how they've structured their finances.
That's right. You called that the stupid tax in the past, and
that's exactly right.
I tend to agree with that. So why is a paper repossession a myth?
Well, in short, it's a myth because the law doesn't recognize a paper repossession, nor does the law allow for it. Now, I've got to give a caveat here. I'm a Florida, Georgia licensed lawyer, so I'm talking about Florida and Georgia law. I will expand a little bit on that in a second, but so what is allowed in another state? Maybe there is a state where a paper repossession is such a thing, but certainly in Florida and Georgia, it's not, and I don't believe it is in most states. And in Florida, it's improper because when a lender holds the security interest in a motor vehicle and they apply for a repossession title, they are certifying to the Department of Highway Safety Motor Vehicles, and this certification is under oath, or you're under penalty of the law. They are certifying that they have repossessed the collateral. And when you dig into what that means literally they have possession of the collateral. And when lenders often refer to paper repossessions, they're not touching the collateral. The collateral remains with some third party, and all they're doing is processing paperwork. And unfortunately, that's not how the law works. The only way the lender can get what's known as a repossession title in Florida is to certify that the loan is in default and that they've taken possession. And as I mentioned, this certification under the law is under penalty of perjury. So if it's untrue, if someone signs that saying we've taken possession of the car and they haven't, that's a felony. So this can have some pretty serious consequences if someone doesn't understand the what the law is in Florida. And so it really is a myth. We can't just process the paperwork.
Wow. I mean, and that sounds scary. That sounds like, what happens if you need that for some reason? You need it to actually be there and you don't have the collateral and everything falls apart. I mean, is that what we're worried about?
Well, no, I mean, what we're worried about is the credit union or the lender not following the proper steps. So what they don't want to do is incur the expense of recovering the collateral and taking possession of the collateral. And so what they are wanting to do is kind of cut corners here. And the reality is the law doesn't allow you to cut corners.
Right. Absolutely. And they're supposed to be the adults in the situation, so to speak, where they follow the rules. I mean, it's a credit union. They're supposed to be very, very responsible. So what about Georgia's title statutes for motor vehicles? Is that similar in Georgia or no?
Yeah, Georgia's statute is worded different than the Florida statute. And in particular, there's not a provision that says, you're certifying under law penalty of, failure to, or false certification is a felony. So it doesn't specifically bring in the felony portion, but there is still an affidavit that is submitted under oath, and it outlines how the titled owner's interest was terminated by the lender. So it's a similar process. The statute's worded different. I don't know that it's subjects the person necessarily to a felony like in Florida, but at the end of the day, it's still improper to apply for a repossession title or transfer title through repossession in Georgia without actually repossessing the vehicle.
I mean, it's good to know the difference, because I know you work in both states, and every law can be a little bit different when it's at the state level. So it's important to have an attorney that understands the differences of what's going on in your state. Are there other laws that come into play other than the motor vehicle title statute?
Yes, there is. So there's Article 9 of the UCC, and this is where I can speak a little bit about other state laws. Article 9 of the UCC, or what's called, the UCC stands for the Uniform Commercial Code, is a law that has been adopted in all 50 states. Now, when it gets adopted in other states, sometimes there are amendments or changes to it. So even though it's supposed to be a uniform statute, it's not always 100% uniform. But this statute was adopted in Florida. The statute's adopted in Georgia, and like I said, all other states. And under this statute, it governs the right of a creditor to take possession of or repossess collateral. And under that statute, the lender or lien holder can only take possession, can only repossess collateral after default. So, when we're talking about the title standard or title statutes, we're specifically talking about what the law requires for the lender to transfer title. Now, what we're talking about is what the law requires for the lender to take possession. So if the title statutes require possession of the collateral in order to transfer title, then you have to go to Article 9 and look at it. And what happens so many times in these paper repossessions is they're conducted without the loan being in default. So not only do you have the problem with the title standard, the title statutes, which say you can't transfer title unless you're in possession, but moreover, even if you do try to take possession, you can only take possession where there's a default. So let me go back to the divorce situation, right? Or couple that's separated, whatever it is, whether it's divorce or separation. You have this auto loan that is in Mary's name and John's name, but the car is titled in John's name. John is not paying the loan. Mary now has the car. She's maybe driving it, but she wants the car in her name. She doesn't want it to remain in John's name. And so the credit union wants to help get the car into Mary's name because she's the one paying the loan, and they want to encourage her to continue to pay the loan. But the auto loan may not be in default. So they can't do a repossession. They can't do a paper repossession. And so a lot of times, what the recourse in that situation is really Mary needs to hire a lawyer and sue John to get title in her name. And the borrower doesn't want to do that. They want the credit union or the lender to fix their problem. And a lot of times that's, where this comes from.
Wow, we're going to need to whiteboard this next time. There's a lot of moving parts, and that's why you need a professional to help you figure it out when there's a problem. So let's talk a little bit about where this myth originated. Who started this?
That I don't know. I'd like to find the person who started this and, have a conversation with them. But I think here's where it does come from in the more general sense is, I think generally it comes from the desire of credit unions in general to help its member, to help some third party. So, take, for instance, the death of a borrower, that situation, right? Let me paint a picture of how this could come up. So we have a member of the credit union who is a dad. He has bought and financed a car for his daughter She's taking the car and going off to college. The car's been hers a couple years. She's off in college a couple years, and dad all of a sudden dies. Let's assume there's no mom in the picture. Daughter's now 21. She needs the car. Let's assume she has the ability to continue to pay for the auto loan. She's paying the auto loan, but she needs the car in her name, and the credit union wants to help her. Right? This is a sad situation. The daughter didn't bring this on herself. She's a victim of a terrible circumstance. She's lost both parents. She's in college. She needs this title, and so the credit union just kind of says, "I know what we'll do. We'll help you," and they do the quote unquote paper repossession and transfer title from dad, who's now deceased, to daughter. And, it may seem like, hey, that's one of those situations where is the harm? Where is the foul? But again, remember, in Florida or Georgia, it's not legal to do that without actually taking possession and going through the repossession process. And then furthermore, there's always a trap. What if dad has another child and that other child has a claim to the car? Florida and other states have probate statutes that define who gets property of dad when he dies. And so if there's a brother or sister or other heir who has an equal claim to the property, they show up, they're now going to have a claim against the credit union because the credit union improperly transferred title. And, to me, this all falls under the saying, no good deed goes unpunished. I think a lot of times the desire to help clouds judgment, and the credit union or lender fails to understand or see the potential trap. All they see is this 21-year-old young lady who needs help. She doesn't have help. She doesn't want to spend the money on a lawyer, or maybe she's limited in resources and can't spend the money on a lawyer. And the credit union wants to wade in and solve her problem. And really, that's where I think a lot of these myths originate from.
Yeah, like you said, no good deed goes unpunished. And it's just, there are so many things that could go wrong. And it's not always the top person making that decision either. I mean, would you say that this is a situation where somebody working somewhere else other than like the president or someone who would really enforce rules, might just take it upon themselves to push something through and not tell anyone else and not follow procedure and protocol?
Yeah, I think a lot of times this is handled at the lower levels, and exactly as you said, the proper authorities or leaders are not consulted, not always aware of this, and they usually aren't aware until a lawsuit hits, and then all of a sudden it's like, what do you mean we were doing this? And that happens a lot. Yes.
Well, I mean, you can see where somebody would, just be doing this out of the goodness of their heart and not realize what kind of pain it could cause the company they work for later on if something goes wrong. So it just goes to show, you just really have to, what do they say? Inspect what you expect. And this is a really good example of why a lot of your clients love using you for ongoing training and setting up those procedures, protocols, so that they do have checklists and things that they can look at to make sure that everybody is falling in line and following the rules.
Yes, training, education is so important in this. So many times I see that, collection staff doesn't understand how to deal with the death of a borrower, and they don't understand all the potential complications, and all they see is someone who's hurting. And we as humans, we want to be sympathetic or empathetic towards those people, and a natural tendency to help, but with education you can educate kind of how to help, how not to help. And so that is one of the things we do. We work with our clients to educate their staff on what they can and can't do. And then, how to spot these issues and when to bring in the lawyers for help, having a knowledgeable lawyer to reach out to and say, hey, here's the situation. We want to help our member. What are our options? And, because we represent so many credit unions in Florida and Georgia, and I've been doing this for 20 plus years, I've seen most situations. Most situations are not new to me. I've seen them before. I know the options, I know the pitfalls, I know the concerns. And so I can, help guide the client through that and help them reach the objective without stepping on the landmines or falling in the traps, whichever analogy you want to use.
I mean, I think that's great. Is there anything else that they can do to avoid this type of issue? I mean, it sounds like, the training and having an experienced professional like yourself that's in there and you know what to look for and you know where the pitfalls are. I didn't want to miss anything else that you wanted to add to that.
Yeah, I think the last part is just I had a mentor who used to have this saying, and a lot of times this went over people's heads. Sometimes people would think, what exactly is he saying? But he used to say, credit unions, they take their members on as children to raise and rear. And what he meant by that simply was sometimes credit unions treat their members like children, and they want to be responsible and walk with them kind of in every situation. And really, I think, the credit union has to understand what is its job. And, its job is never to act as that person's lawyer or that person's advisor, right? We feel sorry for the daughter who lost her dad. But the credit union is not her grief counselor. The credit union is not her lawyer or financial planner. We can certainly help her with financial decisions, but when it comes to how to transfer title from dad to herself, that is not a thing for the credit union to get involved in, because again, they're not her lawyer. And so, again, it's sometimes allowing the heart to lead us in places we shouldn't allow emotions to cause us to make bad decisions. So, there needs to be red flags in those situations. Look, we really need to be careful. What is the goal here? What is my job here? And, at the end of the day, their job is to protect the credit union and make sure the credit union's loan gets paid and make sure that the credit union's collateral. And, we can certainly be sympathetic with the daughter in that scenario. We can help her find options and who to talk to. And in that example of the daughter, there is a process in Florida, and we didn't mention this, but just as an aside, there is a process in Florida where the daughter may be able to go to Department of Highway Safety Motor Vehicle and get the title transferred in her name without a lawyer and without going through probate. But again, that's not the credit union's responsibility to do that for her. We can point her to that and say, you should contact Department of Highway Safety Motor Vehicle and see what you can do, and here's their number. But let's not jump in both feet and all of a sudden do something that's illegal in the name of helping the client or helping the member.
Oh, yeah, I agree with you. And you're right. And sometimes it just takes a little research and some phone calls, and you can solve the issue yourself without having to put the credit union at risk, which is really of the utmost importance. And that's why we have you. So, I want to just let everyone out there know, if you have any questions about what's happening with credit union law, we've recently done a fantastic interview on several updates that have just happened within the last few weeks. And you need help with any other type of credit union issue, Sorenson Van Leuven is an amazing law firm. They really do treat you like family, but not in the way that would get you in trouble later, like some of these credit unions are doing. And they're just fantastic to learn from, educate your staff, and really mitigate a lot of your risks and costs later on when you could possibly have a bunch of people suing you for making the same mistake over and over again. And that you can really keep yourself profitable and in business for a long time by using a law firm. I want to thank everyone for watching. I want to thank you so much, Jim, for helping us out today with giving us one of the myths that we're looking forward to hearing about in the next few weeks. And, we will keep watching these videos and educating ourselves on, what's really up and coming in credit union law.
Thank you for having me, Erica. I look forward to talking to you again soon, and as we talk about other myths.
It's going to be great. Thank you so much. Have a great afternoon, everyone.